Fast-track cases. Claims on the scale of £5,000 to £25,000 required a quicker and simpler way of coping with them. In 1998, before the Woolf Amendments, figures for the year indicate that the total processing period for lawsuits in the county court was 85 weeks from the date of the filing of the petition until the final hearing in the trial. As well as complications, the situations were too costly. Indeed, the Woolf Study showed that the expense of cases was always higher than the sum reported. As a consequence of that, a revolutionary fast-track concept was implemented. When a lawsuit has been decided, the district judge may submit the distribution request to the county court and then make a determination as to whether the dispute is eligible for a swift trial. Personal injuries and accommodation incidents in excess of £1,000 and up to £25,000 are also classified as fast-track events. The quick track indicates that the court must set a very tight timeline for the pre-trial hearings. This is meant to discourage either of both parties from losing resources and building up excessive expenses. After a case has been identified for a trial, the goal is to get the case considered within 30 weeks. The new timetables also significantly reduced delays. For 2011, it took 56 weeks to wait from the question of the lawsuit until the tribunal. This is a 7-month increase on the pre-Woolf age. However, the cumulative duration of 56 weeks is also a long period to wait for prosecution on what is supposed to be a fast-track event. The main jury will typically be held by the circuit judge and will take place in the open court in a more structured process than in the case of civil claims. In order to speed up the trial process, the hearing will be restricted to a period of 1 day, and the number of expert witnesses will be reduced, with normally just one specialist permitted. Multi-track cases. Claims with greater than £25,000 are typically distributed on a multi-track system. When the dispute has been taken to the county court, it is expected to be heard there, but it can be appealed to the Supreme Court, in particular with cases costing more than £50,000. The case will be heard by a circuit judge who will also be expected to manage the case from the moment it is allocated to the multi-track route. The judge can set timetables. It is even possible to ask the parties to try an alternative method of dispute resolution in an effort to prevent waste of costs. High Court. The High Court is based in London, but it has judges in 26 towns and communities throughout England and Wales. This has the authority to prosecute every criminal lawsuit and has 3 sections, one of which specializes in handling other kinds of litigation. These sections include the Queen's Bench Division, the Chancery Division and the Community Section.